In breaking news, the same 3-judge appellate panel in D.C. that had ruled against Donald Trump a day or so ago and his use of the Alien Enemies Act to deport people, kidnap and deport them without due process, that same 3-judge panel, now flipped the other way, has decided that it's okay for Donald Trump to fire at will those independent board members of the Merit Service Protection Board and the National Labor Relations Board that Congress established as a bipartisan way to protect federal workers from retaliation and retribution. They've been retaliated against and had retribution visited upon them. But Judge Walker and Judge Henderson now have joined together and decided that that's okay. What we're watching is the battle for the soul of America again. Are we going to be a country where there is a unitary president with all executive power in one person who has power to defeat congressional will about funding, about independent bipartisan boards, or are we not? They just turned over the game board of 90 years of precedent in making that decision. I'll break it down for you here on Legal AF. Now, look, it's not a repeat hot take. Just 2 days ago, I did a hot take about, on Wednesday, the same 3-judge panel. Sometimes they stay together and handle multiple appeals. They happen to get in sequence 2 Trump appeals, one on the Alien Enemies Act coming up from Judge Boasberg. They affirmed Judge Boasberg's injunction to stop Donald Trump. But, there was a lot of eggs that were broken for that omelet. Let's just put it this way. Millett and Henderson, an Obama and a Bush appointee, kind of got together. But again, there was no unanimity. Everybody wrote their own opinion. So you had 2 concurrences and 1 strong dissent by Walker, who's the Trump appointee, but it was 2-1 in favor of Boasberg and the ACLU and against having people kidnapped in the middle of the night and sent without due process to El Salvador. Same 3-judge panel, fast forward to Friday, 2 days later, same thing happened. 3 opinions are written, 2 concurrences, 1 dissent. But now in dissent is Millett, who was the Obama appointee, and she's angry because the other 2 just threw over, as I said, the game board of 90 years of precedent, starting with a case called Humphrey's Executor from the 1930s, which was affirmed in 2020 in another United States Supreme Court case called Celia Law, which stands for the proposition that if Congress establishes for the executive branch an independent body, and historically this is what they did in the 1930s to protect labor workers, unionized workers and federal workers who were being terribly abused until that moment. They established a precedent, and they established this new reformation of the civil service laws as well. Combine those things together, and what do you have? You have the Supreme Court that has said that as long as the Congress sets these up as bipartisan panels, as long as they don't exert too much executive power, and they don't here, they just do internal investigations about federal workers and about the relationship between collective bargaining and the federal government. That's not exercising executive power. That's just doing things from an administrative independent standpoint. And that's the dividing line in the line of cases. So for Judge Millett, what her 2 colleagues just did, and she's angry about, is that they just ignored all of this precedent. Walker, who wrote a strong opinion in favor of the Trump administration, is a Trumper, is a unitary president model person who thinks the president has all of the power, almost like a king, and rises above the other 2 branches. People like Millett and other judges like Beryl Howell believe that the unitary president model is a fiction that was created by strong-arm bully presidents to try to have Congress and the courts get out of their way. And that's what we're watching. And on the United States Supreme Court, which is where it really matters next, you got a little bit of a split. You've got the unitary president model people, Alito, Thomas, Gorsuch, and probably Kavanaugh. But then you got the people who are not so sure that is historically what is appropriate. or from a precedential standpoint, that is what is appropriate. And I think Roberts and Amy Coney Barrett fall into that category. On the other extreme are the three votes, Ketanji Brown Jackson, Kagan, and Sotomayor, who don't believe in the unitary president model and believe in checks and balances and our structure of government, co-equal branches of government. All came to a head with this new decision. Let me tell you the result of the decision. The result of the decision is that with the removal of the National Labor Relations Board person, Wilcox, and the removal of the Merit Service Protection Board person, Harris, there's now not enough people. There's not enough quorum to do business, to conduct the business and function. So Donald Trump, by removing and not replacing Wilcox, removing and not replacing Harris, and the only reason is he doesn't like the color of their party, you can fill in the blank, he's now immobilized them because they don't have a quorum, they can't act, which is what he wanted to do. So now he's removed and effectively defunded and defanged a group set up by Congress to police the federal government in its relationship with federal workers and collective bargaining. He's now decapitated them. And that is something that Millett has mentioned as well. Let me read to you from Millett's dissent. It's powerful. And it just shows you how the shifting alliances happen on a appellate panel and at the United States Supreme Court panel. We've always said here on Legal AF and on the podcast, if you want me to tell you how the appeal is going to go, tell me who the judges are. Tell me who the judges are. Tell me who appointed them, and I'll be able to tell you how the case is going to come out because of these philosophical divisions and debates that we see burst out in the open in reporting like this. So here when I heard it was Henderson, Millett, and Walker on the first case with the Alien Enemies Act, I was hoping that Henderson, who had been on the right side, if you will, of holding Donald Trump accountable criminally and finding that no immunity applied in the underlying decision, or in some other cases involving Donald Trump in the past when he was not a candidate at the moment. I thought, all right, well, Henderson's a little bit of a wild card, but I think she'll get there. And I was hoping it would end up being 2-1, and it was in the right direction. Now, Henderson has decided, I don't know if it's a make good, a gimme, like when the umpire blows a call, gets a lot of grief. I'm sure she got a lot of grief. And then gives a call safe at first base in the next play, even though the person wasn't really safe. There might be a little makeup going on here. Here's what Millett in dissent wrote this time around. The two opinions voting to grant a stay, that's Henderson and Walker, rewrite controlling Supreme Court precedent and ignore binding rulings of this court, all in favor of putting this court in direct conflict with at least two other circuits, other appellate courts. The stay decision also marks the first time in history that a court of appeals or the Supreme Court has licensed the termination of members or of multi-member adjudicatory boards statutorily protected by the very type of removal restriction the Supreme Court has twice unanimously emphasized upheld. What is more, the stay order strips the National Labor Relations Board and the Merit Systems Protection Board of the quora that the district court's injunctions preserved. In other words, they can't operate. They're short people, disabling agencies that Congress created and funded from acting for as long as the president wants them out of commission, forever. That decision will leave languishing hundreds of unresolved legal claims that the political branches jointly and deliberately channeled to these expert adjudicatory entities, all branches. In addition, the majority decision's rationale openly calls into question the constitutionality of dozens of federal statutes conditioning the removal of officials on multi-member decision-making bodies, from the Federal Reserve Board, the Nuclear Regulatory Commission, to the National Transportation Safety Board, and the Court of Appeals for Veterans Claims. In other words, it's all up for grabs now. He can just fire everybody if this precedent is followed. Millett continues on page 61 of her decision. That would be an extraordinary decision for a lower federal court to make under any circumstances. But what makes it even more striking is that all we are supposed to decide today is whether a stay is pending appeal, or whether a stay is appropriate. So let me back out for a minute. This is not about the merits of the case. This is about whether the two decisions that got from the trial court level, one from Beryl Howell, on Wilcox, the other from Rudy Contreras on Harris. Those two trial court decisions, which they put consolidated together for this appeal, as I thought they would. There was a third case involving Hampton Dellinger, who was the head of the Office of Special Counsel, who has another role in all of this, but he threw in the towel. He's like, yeah, I'm out. and he would have been on the bad end of this decision had he stayed. So maybe he was smarter than I actually gave him credit for at the time. But the two cases that came up, right, from the lower court decisions, only was about whether the injunctions that these two judges entered to force those Wilcox and Harris to stay in their seats during the appeal, whether that's right or wrong. This is not about whether the power is proper. It's about whether the seats should be filled during the appeal. Now, the argument on the majority side is, yeah, but they're going to lose on that argument. The likelihood of success on the merits prong of this analysis is in favor of the Trump administration. So we're going to take them out now so they're out. They were in based on this decision. They're now out, although the parties on the losing side have asked the court to stay their decision to give them time to go to the United States Supreme Court and allow these people to stay in their seats and continue to operate with the quorum. As to the narrow question, Judge Millett ends, the stayed decision is an unprecedented and, in my view, wholly unwarranted use of this court's stay power, which is meant only to maintain the status quo pending appeal. So you can see, because they've been together for a couple of cases now, Henderson, Millett, and Walker. I'm not saying they don't get along, but Walker certainly reveled in the fact that he was able to drag Henderson over to his side on this case, having been on the losing end of 2-1 in the case on Wednesday. That's what happens. And that's what I think is interesting for us to follow for you here. Give me the judges, give me the lineup. But even there, if you gave me the judges and the lineup, I would have thought Henderson would have sided with Millett for a second time, 2-1. Maybe she just lost her confidence, didn't want to get bashed anymore, or just the way she interprets a unitary president model. As it relates to agencies, this is where she comes out, as opposed to when she ruled he doesn't have the power to declare war. See, this is the same judge, Judge Henderson, where she sided with Trump now, but on Wednesday, she wrote in her opinion a version of a migration of terrorist gangs. An immigration of terrorist gangs is not an enemy invasion, not an incursion, not a predatory invasion, not a war. So war powers, she's not in favor of Donald Trump declaring a phony war, Henderson. Here, his lording over all of the executive branch probably fits with her unitary presidential model. I've seen that touched on before in her prior rulings. So that's where we are. What happens next? They've asked for a stay. They'll probably give them a stay. Either way, there's now going to be an appeal, an attempted application over the weekend or on Monday to the United States Supreme Court. We'll follow it right here on Legal AF. I'm glad you're here. I'm Michael Popok. I curate all the content here on Legal AF. We got the Legal AF podcast on Wednesdays and Saturdays at 8 p.m. Eastern time. I got a new podcast called Popok Live. You guessed it. It's like a TED Talk meets a law school class meets Jimmy Kimmel Live, except with me. Tuesdays, 8 p.m. Eastern time on the Midas Touch Network. And then, of course, wherever you get your podcast from, pick up Legal AF. We're top 10 in the world. It's all because of you, really. We're indebted. I'm indebted from the bottom of my heart. So until my next reporting, I'm Michael Popok. I'm Michael Popok, and I got some big news for our audience. Most of you know me as the co-founder of Midas Touch's Legal AF and the Legal AF YouTube channel, or as a 35-year national trial lawyer. Now, building on what we started together on Legal AF, I've launched a new law firm, the Popok Firm, dedicated to obtaining justice through compassionate and zealous legal representation. At the Popok Firm, we are focused on obtaining justice for those who have been injured or damaged by a life-altering event by securing the highest dollar recoveries. I've been tirelessly fighting for justice for the last 35 years, so my own law firm organically building on my Legal AF work just feels right. And I've handpicked a team of top-tier trial fighters and settlement experts throughout all 50 states known as big auto injury attorneys who have the know-how to beat heartless insurance companies, corporations, government entities, and their attorneys. Big Auto's attorneys working with my firm are rock stars in their respective states. States and collectively responsible for billions of dollars in recoveries. So if you or a loved one have been on the wrong side of a catastrophic auto, motor vehicle, rideshare, or truck accident, suffered a personal injury, or been the victim of medical malpractice, employment harassment or discrimination, or suffered a violation of your civil and constitutional rights, then contact the Popok firm today at 1-877-POPOK-AF or by visiting my website at www.thepopokfirm.com and fill out a free case evaluation form. And if we determine that you have a case and you sign with us, we don't get paid unless you do. The Popok firm, fighting for your justice every step of the way.